Picture this. You are driving down the highway, minding your own business, completely sober, following every rule of the road, when suddenly red and blue lights explode in your rearview mirror. Your stomach drops. You pull over. The officer walks up to your window, and within the next 3 minutes, with just a few wrong words or one bad decision, your evening turns into a 4-hour nightmare on the side of the road, your car gets searched, and you end up with a citation you never deserved. Here is what nobody is telling you. Most traffic stops end in your favor or drag on into a constitutional nightmare based entirely on what you say and do in those first critical moments. And right now, there are 6 specific legal tricks that lawyers actually use, tricks pulled straight from Supreme Court rulings and real courtroom case law, that can end almost any traffic stop immediately. If you want to know how to protect yourself every single time you get pulled over, hit subscribe right now, because we break down your rights in plain language every single week on this channel. Stay with me, because the next few minutes could save you from an illegal search, an unlawful detention, or worse. I have spent years dissecting traffic stop case law, reviewing hundreds of body cam recordings, studying the Supreme Court decisions that most officers hope you never read, and analyzing the exact psychological tactics police departments train their officers to use on drivers just like you. I have identified 6 specific legal moves that force a traffic stop to end fast, protect you from illegal searches, and create an airtight record if anything goes wrong. This is educational content only. Nothing here is legal advice. For your specific situation, always consult a licensed attorney in your jurisdiction. With that said, let us get into it. Trick number 1, the status declaration. This is the single most powerful move you can make at any traffic stop, and almost no one knows it. Here is how most stops go wrong from the very beginning. The officer walks up, collects your license and registration, runs your info, comes back, hands you your documents, and then says something like, "So where are you headed tonight?" And you answer. You say you are just heading home from dinner, or from a friend's house, or from work. The moment those words leave your mouth, you have handed the officer the one thing he needs to legally extend that stop, a reason to keep talking. Here is the legal reality that law school professors teach, but nobody puts on the internet. Every single police encounter falls into one of 3 legal categories. A voluntary encounter, where you are free to leave whenever you want. A detention, where the officer must have reasonable suspicion of a crime. Or an arrest, where they must have probable cause. The problem is that officers are trained to blur the line between voluntary and detention, because if you don't know which one you are in, you will keep talking, keep giving information, and keep extending a stop that should have been over 3 minutes ago. The exact phrase you need is, "Officer, am I free to leave or am I being detained?" Say it calmly, say it respectfully, but say it clearly. This question does something no amount of polite cooperation can do. It forces the officer to legally define your interaction on camera. If he tells you that you are free to go, you say, "Thank you, officer." Roll up your window and drive away. The stop is finished. If he says you are being detained, everything has changed, and now you know which rights apply. The reason this works is not just psychological. It is legal. In Rodriguez versus United States, the Supreme Court ruled that officers cannot prolong a traffic stop beyond the time needed to handle the reason they pulled you over. The moment you ask about your status, you put a legal clock on the interaction, you signal that you understand the rules, and you create a documented record in case things escalate. Wrong way, the officer asks where you are coming from. You explain your whole evening in detail, and what started as a taillight stop becomes a 30-minute interrogation. Right way, the officer asks where you are coming from. You ask if you are free to leave. He has to decide right then and there without a reason to keep you, most of the time you drive away in under 2 minutes. The status declaration ends fishing expeditions before they start. Trick number 2, the detention clock. Even when the officer says you are being detained, the stop still cannot last forever. In fact, it has a strict legal deadline, and most drivers have no idea they can enforce it. After studying over 200 traffic stop cases, the single most common mistake I see is people sitting on the side of the road long after the legal reason for the stop has already ended, simply because no one told them they could leave. The Supreme Court was unambiguous in Rodriguez. A traffic stop may last only as long as it takes to complete the mission of the stop. The officer pulled you over for speeding, he issues the ticket, and that is it. The legal justification is gone the second that ticket hits your hand. The exact words to use are, "Officer, has the purpose of this traffic stop been completed? Am I free to leave?" Here is how it plays out in the real world. Officer pulls you over for a broken tail light. He writes the warning, walks back to your car, hands it through the window, and then casually says, "Mind if I ask you a few questions?" Most people think they have to stay and answer. They don't. The moment he handed over that document, the lawful reason for the stop expired. You say, "Officer, has the purpose of this stop been completed? Am I free to leave?" If he says yes, you leave. If he says no, you follow with, "For the record, what additional violation am I currently being investigated for?" That question is a legal hammer. He cannot say he just wants to chat. He needs to articulate specific, reasonable suspicion of another crime. If he cannot provide it on that body cam recording, the continued detention is illegal, and anything discovered afterward can be challenged in court. Compare the two outcomes. Without this trick, the officer hands you the ticket, you sit there, he says you seem nervous, you deny it, he asks to search your car, you hesitate, and 45 minutes later, he is pulling apart your trunk over nothing. With this trick, he hands you the ticket, you ask if the stop is complete, he says yes, you leave, and the whole thing is done in under 2 minutes. The detention clock stops the moment the paperwork is written. Trick number 3, the consent shield. This is the one that matters most, because it shuts down the number one tactic officers rely on to turn a routine stop into a full vehicle search. After reviewing hundreds of body cam videos, I can tell you that officers are extensively trained to frame search requests as casual, friendly, almost obvious. They say things like, "You don't mind if I take a quick look, do you?" Or, "Nothing illegal in there, right? So you'd be fine if I just check real fast?" These are not questions. They are traps. If you say yes, you have just voluntarily waived your Fourth Amendment rights. If you hesitate, say, "I guess," or stay silent, courts have ruled they can count as consent too. And once consent is given, anything found in that search is fully admissible, even if the officer had absolutely no probable cause to ask in the first place. The exact words are, "Officer, I do not consent to any searches." Say it clearly, say it firmly, and repeat it as many times as necessary. The Fourth Amendment protects you from unreasonable searches without your consent, a valid warrant, or actual probable cause. The vast majority of routine traffic stops do not involve any probable cause. The entire strategy depends on getting you to give permission voluntarily, because you feel guilty refusing or you think it will make you look suspicious. It does not. Refusing a search is a constitutional right, not a red flag. Wrong way, the officer asks if you have anything illegal in the car, you say no, he says great so you won't mind a quick look, you say I guess that's fine. And now he is searching every compartment while you stand on the side of the highway for an hour. Right way, he asks the same question, you say you do not consent to searches, he asks why not, and says it will only take a second, you repeat that you do not consent, and now the burden is entirely on him. If he searches anyway, he must justify probable cause on that body cam recording. If he cannot, every single thing he finds gets thrown out. This has happened in real cases. Officers searched after consent was refused, found contraband, and the case was dismissed because the search was ruled unconstitutional. The consent shield stops illegal searches before they begin. Trick number 4, the scope challenge. Even if the officer orders you out of the vehicle, there is a legal move that limits exactly what can happen next. This is the scope challenge, and it is grounded in a Supreme Court ruling most people have never heard of called Pennsylvania v. Mims. That case said officers can order you out of a vehicle, but only based on specific, articulable facts related to officer safety. Not a hunch. Not because they feel like it. Specific facts. The exact phrase is, "Officer, are you asking me or ordering me to exit the vehicle?" If he says he is asking, you can decline. If he says he is ordering you, you follow with, "For the record, what is the lawful reason for ordering me out of the vehicle?" This does two things simultaneously. It forces the officer to articulate his justification on camera, and it establishes clearly that you are complying under protest, not voluntarily surrendering your rights. Here is why this matters more than most people realize. Once you are outside the vehicle, officers have significantly more physical control over the situation. They can conduct pat-downs, position you away from your car, and claim they observed something in plain view through the window. But if the order to exit was unlawful, any evidence obtained from that point forward can be challenged and suppressed. Before using this trick, officer says get out, you comply, he pats you down, finds something, you are arrested, and in court his only justification is that he ordered you out for safety, which almost always holds up because you never questioned it. After using this trick, officer says get out, you ask if he is ordering you, he says yes, you ask for the lawful reason, he states it on camera, you say you are complying under protest with your hands visible, and now your attorney has a documented record of every justification he claimed, which can be challenged in court if any of it was pretextual. The scope challenge creates the legal record that protects you after the stop ends. Trick number 5, the silence invocation. The fifth trick is the simplest in theory, and the most misunderstood in practice. Invoking your right to remain silent the correct way. Here is the critical mistake people make constantly. They think that simply staying quiet is enough. It is not. In Salinas v. Texas, the Supreme Court ruled that silence alone can actually be used against you in court unless you explicitly and verbally invoke your Fifth Amendment right. That means you have to say the words out loud. The exact language is, "I invoke my right to remain silent, and I want to speak to an attorney." Both parts matter. The first part legally stops questioning. The second part triggers your Sixth Amendment right to counsel, which requires officers to halt all interrogation immediately. Anything asked after you invoke these rights cannot be used against you. Without this trick, the officer asks how much you have had to drink tonight, you go quiet, and in his report he writes that you refused to answer and appeared nervous. In court, the prosecution argues your silence shows awareness of guilt. With this trick, the officer asks the same question, you invoke your rights out loud, and he is legally required to stop questioning you on the spot. If he continues, every answer after that point is inadmissible. The progressive mistake is staying quiet through 3 or 4 questions until you hesitate on the one that matters, and that hesitation becomes the reasonable suspicion for a field sobriety test. The right move is to invoke at the very first question you are uncomfortable with. Invoke clearly, invoke early, and never feel the need to explain why. Trick number 6, the first 30 seconds protocol. Before any of these 5 tricks can protect you, you have to survive the opening of the stop safely and strategically. When you see the lights, Pull over immediately using your turn signal so the officer notes your cooperation from the start. Turn off your engine. If it is dark, switch on your dome light so the officer can see clearly into the vehicle. Place both hands on the steering wheel in plain view. Lock your doors. Roll your window down only 2 to 3 inches, just enough to pass documents through. Then say calmly and clearly, "I am locking the vehicle for safety. I will pass my documents through the window." This protocol matters because it controls access to your vehicle from the very first second. If the officer cannot freely see into your car, he cannot make a plain view observation claim about something he spotted inside. It establishes your cooperation without exposing you to unnecessary risk, and it sets the tone for everything that follows. A few things vary by state that you need to know. In Texas and Florida, the odor of marijuana may still justify a search because it remains illegal. In Colorado and Maryland, courts have ruled that smell alone is not sufficient probable cause since marijuana is legal. Some states have stop and identify laws that require you to provide your name and identification on request, even as a passenger. In Indiana, drivers must provide their name, address, and date of birth. In California, only the driver is required to show identification. Know the specific rules for your state. But the core 6 moves, declaring your status, enforcing the detention clock, refusing consent, challenging scope, invoking your right to silence, and controlling the first 30 seconds, apply everywhere and protect you in every jurisdiction. Here is the principle that holds all of this together. A traffic stop is not a conversation. It is a legal interaction, and every second of it is governed by constitutional law. You are not required to be a passive participant. You have the right to know your legal status, the right to remain silent, the right to refuse searches, and the right to challenge unlawful orders. Using these rights does not make you confrontational. It makes you protected. The 6 exact phrases to commit to memory are, "Am I free to leave or am I being detained? Has the purpose of this stop been completed? I do not consent to any searches. Are you asking me or ordering me to exit? For the record, what is the lawful reason? I invoke my right to remain silent, and I want to speak to an attorney." Write them down. Practice saying them out loud. Put them in your phone. These are not just words. They are the difference between a 3-minute stop and a 3-hour nightmare. The next time those red and blue lights appear in your mirror, you will know exactly what to do, exactly what to say, and exactly how to protect yourself at every stage of that encounter. Remember, this is educational content only, not legal advice, and every situation is different. Always consult a qualified attorney licensed in your state for guidance on your specific circumstances. If this gave you something valuable, subscribe to this channel right now because we publish videos every week on your rights, how to use them, and what the law actually says in plain language that anyone can understand. Hit the bell so you never miss a video that could protect your freedom. Share this with every driver you know, because this information belongs to everyone, and knowledge of your rights is the most powerful thing you can carry in that car.